First on the agenda is discussion of possible action to hire Gerald Hilsher as legal counsel for the defense of DEQ emergency order case number 11-177 and assessment order case number 10-351.
If you all have any questions of Mr. Hilsher now, you can go ahead and just inquire, and then we have a contract that his office has compiled and prepared for you all to review.
Okay. I was told earlier that this is not the first one that you've done with the
No, I've defended actions for the DEQ for about the last 10 years on a variety of different items. You want me to tell you all a little bit about myself and the practice? Okay. My name is Gerald Hilsher. I'm a lawyer with the McAfee and Taft law firm. We've got offices in Oklahoma City and in Tulsa. I'm from the Tulsa office. I have 32 years of legal experience. I've been a prosecutor, kind of like Ms. Pratt, early in her career. I've been a prosecutor. I've been an assistant U.S. attorney. I've been a U.S. Department of Treasury law enforcement official. And then after I got through playing around with that, I got serious about the civil practice of law in the late 80s, and I've done nothing but litigation work. That means trial work, administrative, agency matters, etc. I have been involved in environmental matters since 1997 when Frank Keating appointed me to an animal waste and water quality protection task force when he was governor. And he also appointed me to the Oklahoma Scenic Rivers Commission that looks out after the Illinois River and those scenic rivers associated there. And I've been actively practicing as a part of the Oklahoma Bar Association's environmental litigation section. In fact, I've been the treasurer, I've been the chair-elect, and last year I was the chair of the environmental law section. And the environmental law section is a group of lawyers that includes lawyers that are associated with state agencies, like Department of Environmental Quality, like the lawyers that are at the Oklahoma Water Resources Board, lawyers that are at the Oklahoma Corporation Commission. So all of us are together at meetings 4 times a year, so I know who all the players are, in addition to litigating against those players, or mainly what you do when you're involved in an administrative action with a government agency is you negotiate to a resolution. There are some times when you just can't agree. You agree to disagree, and you have a hearing. And the hearing is in front of an administrative law judge who rules on facts and the law and makes a recommendation. And the recommendation goes up then to the director of the DEQ, and those decisions can then later be appealed. But the bulk of the work that's involved in trying to resolve one of these types of cases is the state says you ought to be doing this, that, and the other thing to take care of violations that they believe are happening. And that, of course, means spending money, hiring contractors, and all of the things that you've been doing for the last 8 months. Somehow there's not a sense on the other side of that what you've been doing is enough. I think they've got some misinformation. And the reason I think I've been invited here tonight is because the DEQ is pressing for a hearing to take place on March the 8th. And this administrative law hearing would happen in Oklahoma City. It would require witnesses on your side. It's going to require witnesses from their side. It's still not too late, in my opinion, to prepare the case, and Ms. Pratt has done a great job of coordinating at the same time that you've been trying to do the work, trying to keep up with, well, this is what we're doing, but it seems like the other side may not be listening as hard as they need to be listening to find out what's going on. So if the board decides that you need a little additional assistance to negotiate and persuade our way into an agreed resolution, I think I can assist in that because I know the parties and the players over there. And I think you've got a good base right now to get it worked out. But if we have hard-headed people on the other side that we can't persuade to be a little bit more agreeable, then I can certainly assist Ms. Pratt in putting on a case that I think would be effective for your needs here. The way we would do it, because I know everybody's concerned about why are we spending money on lawyers when we need to put the money into fixing the problems that have been identified. My paralegal here is an experienced litigation paralegal who has worked with me for over 10 years, and we worked opposite each other when she was with the firm that I'm now with before that. So she's got 20, well, if I say any more than that, I'll disclose her age, but she's got 20 good years of experience at least in doing this kind of work. And basically I brought her down here today if we get hired at no expense so that she can meet you and Teresa and Tinker so that we can shift the work of organizing and doing the work that she does for me daily at a cheaper rate so that we can get the case ready and save the work for Ms. Pratt and myself on the phone with the decision makers at DEQ to say, now wait a minute. Here's the information that we've got from Mr. Gord, who's doing the work, from Robert Vaughn, who's the engineer, from the operator, and we're going to put it into a fashion with her help and Tinker's help that sells our position. And if we can do that and do some persuasion, great. If we can't, that same evidence that we're putting together for the persuasive negotiation aspect, well, that's what we take to trial. So I think our firm does, and I certainly do myself, try very hard to make what we're doing for you as efficient as possible. The problem is, you're way down here, I'm in Tulsa, and our venue is in Oklahoma City. So that's why we've got to coordinate as well as we can to do this by email, do it by fax, do it by telephone conference call. Although I've got to tell you, sometimes the way you get these things resolved is sitting down across the table with your briefcase full of copies of exhibits and saying, now, when I say this, what are you going to say to that? So I'm not telling you that it's not going to involve, in order to get this thing done, a trip to Oklahoma City. It's certainly not. And it might mean that the both of us go down to Oklahoma City because she's got the institutional knowledge of 8 months, and I've got some of the knowledge of the processes and the people and everything else. So you're in a spot, you need to get out of the spot. I think I can help you with that. I think I can do it efficiently. I know we can do it efficiently. So if that kind of gives you a background, I'm ready to answer any questions that the board might have.
I have
Yes, ma'am.
my obvious question is, and Council Pratt, our fine is $8,120, right? How much is it going to cost us to defend against that? Best estimate. I'm thinking it's going to be more than $8,120.
There absolutely is going to be.
Always a possibility of that.
I think it would be. The question is, it's not just the fine. You've also got to work this thing out into a place where you've got a consent order that puts everything to bed.
To resolve the consent order, if we make the repairs, that should take care of that, shouldn't it?
The consent order is the consent order will have requirements negotiated. If you're already done and they put the blessing on it and say, oh, well, now that you've gotten to this point, everything's good, everything's fine, that's not the way those typically come out.
It's just real hard for me to spend that much in attorney fees when we could go up there, take our whipping, if that's what they're gonna give us, pay the fine, try to work out some way to pay the fine out, and go ahead and get the repairs made that will get us out from under the consent order. And then work as hard as we can to never get in that position again.
Yes. That's